We're going to turn to case study 2, which in a couple of seconds will be introduced by Juan Carlos. And this one is somewhat different and potentially somewhat easier than the first case study that we had, hence the reason for which I allowed the first case study to run over time somewhat. I do not expect it should generate that much more conversation, but you never know. And the Riot situation case study that we have here is again in a situation of a non-international armed conflict. And we have a demonstration to protest against the government's repression of the insurgency. And there's 100 or so people gathered on the main street of the capital where government troops are based. Initially, the protest is peaceful. After some attempts by the government army to disperse the crowd, with a loudspeaker for instance, the crowd becomes more aggressive and starts to throw rocks at soldiers. At the same time, fighters take advantage of the riot and attack the soldiers with rifles. Some contend that fighters instrumentalized the population and incited it to demonstrate in order to hide in the crowd and to conduct an attack. And there's 3 or 4 questions there that are on the PowerPoint that hopefully you have before you, again with regard to the issues of law enforcement, conduct of hostilities, and what response are the military/law enforcement officials entitled to take facing such a situation. So I'll pass the floor now to Juan Carlos.
Okay, James, thank you very much. For you in Europe, Africa, and Asia, good afternoon. For those of you who are in America, good morning. First of all, I want to thank the ICRC for this invitation. It is a real honor for me as a human being, Colombian, and a member of the military forces to be part of this web seminar and to share with you some of the thoughts about this interesting but at the same time very difficult topic, that is the use of force in a non-international conflict under the law of armed conflict or law enforcement. For those of you who are not very familiar with the Colombian and its case, I will let you know this is a country that has a history of 50 years in conflict, but at the same time it is a social state of right, in where you find a very liberal constitution that promotes and defends human rights like in not many countries, even in countries that have never had non-international conflict. So that means that in Colombia, military and police authorities are used to be involved in hostilities as well as in law enforcement actions. For today, the moderator, Mr. James, asked me to introduce the case study number 2. In this case, for those of you who haven't had the opportunity to read it, it is about an eventual riot in where at least 100 people are protesting against the government due to the repression of the state against the insurgents. It starts being peaceful, but after a while it goes violent, and some into the multitude or crowd start launching rocks against the soldiers. Show up into the scene some guerrilla members who start shooting to the soldiers. Some contend that the guerrilla members are using the population involved in the riot, let's say civilians, as a human shield. The first question is, what to do? Use in parallel the 2 paradigms of law enforcement to confront the riot, and then when the members of the illegal armed groups show up, change to the hostilities paradigm and confront them under the law of international humanitarian law? Well, I can say, in theory, this sounds perfect. And I can say, yes, this is the best way to act. But unfortunately, this cannot be the instruction for any army that could confront a situation like the one presented in this case. It is very important to avoid any situation like the one presented in the study. To date, you cannot take the army with rifles to prevent a riot in where it's probable to have penetration by illegal actors with rifles. It is important to avoid, by all means, the participation of soldiers in a situation like the one presented here. Always In a case like this, the law to govern the situation will be law enforcement paradigm. And the only explanation of the use of force is in self-defense, in the favor of the civilians and the soldiers who could be affected by this attack. In the case of Colombia, I want to share with you what do we have. Right now, there is a proliferation of social protests. There is and we have a guidance from the Ministry of Defense. And it is pretty clear to explain the way military forces and police have to respond when a riot goes violent. First of all, the responsibility of civilian authorities to respond to the needs of the crowd and avoid any expression of riot or violence. And then, if we can't avoid the violence, we have 3 rings. The first ring, that is with the anti-riot police, with helmet, shield, vest, and non-lethal weapons like pepper spray, tear gases, stun grenades, etc. The second ring is with the police. And just in the third ring, we have the possibility to use soldiers, but just to dissuade, but trying to avoid any contact with the riot. Always, as I said, we think that the law that governs these cases is the law enforcement. And the second question is, the entire situation has to be governed by the law of hostilities paradigm? And I think not at all. It is impossible to justify the use of force in a framework of hostilities in a riot in the capital of a country, even though this country is immersed in a non-international armed conflict. The indiscriminate use of force in a situation like this will never be justified under the principles of military necessity or military advantage. As a legal advisor, I think the only possibility that I see to use force under international humanitarian law and the hostilities paradigm is if I have a sharp shooters or snipers, and with them it is possible to identify those who in the middle of the riot as a guerrilla fighters are using rifles, and I can neutralize them without using indiscriminate force. Only in those cases I will use force with the conviction that I am acting legitimate and legally. The third question, the determination about the paradigm to use is referred to the place in where the protest is taking place, in a rural or urban area. I am not positive about making this asseveration. I think that what really determines the application or the applicability or not of the hostilities paradigm is not the rural or urban situation. I honestly think that one can use hostilities paradigm if you reach 3 objective circumstances: the intensity of violence, the level of organization of the parties involved, and of course you have to differentiate with situations of violence less severe in where it is unthinkable to use force in the framework of hostilities. There is a point that is related with the control, but I think that now that concept we have to reevaluate it, because I think that you cannot say that you apply international humanitarian law in certain place, because the threat can move from one side to another. I think that you can apply here the balloon effect. If you push them here, they will move to another place. So in that case, you can apply international humanitarian law in different places inside the country. Talking about the fourth question, should the whole situation be governed by the law enforcement paradigm? What will be the conclusion that the law enforcement paradigm governs the whole situation imply in practice? I think this is not a correct position. International humanitarian law is a very important and useful tool that is legal and is legitimate. And it could be very, very useful and crucial to confront many of the violent problems that the whole world is facing today. I know there are some academics, also some human rights activists and judges who really want to exclude this part from international humanitarian law rule. States and its authorities are facing very challenging security situations, and the law enforcement paradigm not always is the best response. Yes, rights are very important, and the state has to protect individuals, but sometimes the danger and the risk is so high, and the circumstances allow the state and its authorities to use international humanitarian law rules to confront and to overcome the threat. To end my dissertation, I want to introduce a point that I know it could be very controversial, but I think it is an important point to take into account. It has to be with the rule number 75 in customary international humanitarian law. That is the use of the prohibition to use riot control agents in a non-international armed conflict. What I want to point out is the fact that sometimes the use of these riot control agents that are normally used in riots is in some cases could be and have been used to protect civilians in the middle of hostilities. I had information of 2 different cases, one here in Colombia and other in Afghanistan, in where the use of tear gases saved the life of many civilians and neutralized members of illegal armed groups who were trying to hide themselves and use civilians as human shields, avoiding military action and obtaining a military advantage. I am convinced that under the principle of military necessity and the principle of precaution, it could be legal and legitimate to use of riot control agents by soldiers in an IAC under certain circumstances. I want to stop here and give the opportunity for those who want to participate or ask something to do so. Thank you very much.
Thank you very much, Juan Carlos. And you raised quite a few important issues here, which actually touch quite nicely upon some questions we have been receiving from the attendees. I think your example there of using in exceptional circumstances snipers, for instance, or the last controversial point you made there with regard to the possible use of riot control agents, chemical weapons in inverted commas, in some situations, no doubt will provoke some response from the other panelists. And a couple of questions we received before I turn to the other panelists were exactly that sort of the sniper question in terms of, how do you distinguish, if you have a riot situation, how do you distinguish between military and criminal action? How do you know which components of the military and need to address and which the components of the law enforcement agents should address? And likewise, a question on chemical weapons, which hopefully some of the other panelists would also address in response to your last point. If we look at Additional Protocol 1 of the Geneva Conventions and Article 36, which talks here about review of weapons and legality of weapons in armed conflict situations, and if we know, of course, the issue with regard to the Chemical Weapons Convention and the use of sort of riot control agents, tear gas, being prohibited in conflict situations. How do we address that? Coming back to Juan Carlos's last point. I hope those made sense. I'll turn the floor over to Gloria for any particular additional comments.
Thank you. I think on this case study too, we had really a very important outcome during the expert meeting, and it was highlighted also by Juan Gomez. This first important outcome is that very clearly for all the experts, when there is civilian unrest as such, or other acts of violence which are committed by civilians, but do not amount to direct participation in hostilities, then these acts of violence must be addressed under law enforcement paradigm. So that is already a very important outcome. The second one is that in a case like case study 2, where we have a concurrence of civilian unrest, but also hostilities because the fighters in the crowd start to attack the soldiers, then from a legal perspective, there was a genuine agreement that it is the parallel approach which applies. That is to say that the conduct of hostilities paradigm can be applied against the fighters in the crowd, and they could be targeted by a sniper, for instance, and then for the civilians, even if they are violent, they are rioting, then it's the law enforcement paradigm, and the use of force should be really done as a last resort. This shows that here again, the main criterion for the experts was the status, function, or conduct of the person against whom force may be used, because it depends on that whether you choose the conduct of hostilities or law enforcement paradigm. So the experts did not look at the situation as a whole, but agreed that you need to check whether there are fighters in the crowd, and if you are able to target surgically these persons, then that is not outlawed under the conduct of hostilities. There are, however, even if that makes total sense from a legal perspective, there are practical difficulties with implementation of this parallel approach, because very often it's difficult to distinguish in the crowd between the civilians that are peaceful, those that are violent but not DPAging, the civilians that are indeed DPAging, and the fighters with a continuous combat function. It might be also difficult for armed forces to apply the two paradigms at the same time and at the same place. However, applying the law enforcement to the whole situation, which might be easier from a practical perspective, might lead to unwanted and counterproductive consequences. Because if fighters would be led to believe that they can enjoy more protection from direct attacks if they mingle with the civilian population, then actually we endanger civilian population, because they might think that it's safer to go in the middle of the crowds. So that's why the parallel approach was preferred. I have to say that in most cases, like in the Riot situation, the thing is that if the armed forces choose to attack the fighters in the crowd, this might lead to issues under the IHL principles of proportionality and precautions. So obviously these principles continue to apply. So even if you identify in the crowd some fighters, if attacking them would mean causing excessive collateral damages, would mean that you do not take every feasible precautions because you do not call the sniper, which could come and surgically kill the fighter, then it will cause issues and violations of international humanitarian law. So obviously these principles are key in this situation. So that means that very often in such a situation, probably we will have to find an alternative unless you have a sniper. And I think Juan Carlos, thank you for highlighting that. If you have a sniper, then you can surgically kill, but if you don't, probably it would be more difficult to target and kill surgically the insurgents and fighters in the crowd. But because of these practical difficulties, I think that personally, from a policy perspective, indeed, it would be easier to consider that the whole situation is covered by law enforcement rules, by self-defense rules. Some experts noted during the expert meeting that in many rules of engagement for such situations, it's self-defense rules that are provided for. So for policy reasons, I think it's easier if we take the situation as a whole and consider that it's the law enforcement, even if legally speaking, the right approach would probably be the parallel approach. Thank you.
Thank you very much, Gloria. Again, so raising up a few issues with regard to sort of the law and policy kind of a question marks that we have about what is legally the appropriate way to approach this particular situation over what will be the policy choice to approach this situation. And looking at, of course, a parallel approach of trying to address the situation with both a conduct of hostilities hat as well as a law enforcement hat where possible to separate one from the other. And of course, the issue we have here referred to on a couple of occasions, this new verb of DPHing. For those of you not familiar with it, we're talking here about the concept of direct participation in hostilities, and someone who's DPHing is someone who is participating in hostilities, which is based on the 2009 ICRC guidelines on direct participation in hostilities. I'll give the floor to Richard to address this question of the parallel approach, law enforcement or conduct of hostilities preference in these situations, and maybe even address the question of the use of tear gas or chemical agents in a law enforcement paradigm.
Yeah, thanks, Jamie. I mean, the first thing I would say is, you know, and this goes both for the sleeping fighter situation, but the third case study, which if we have time, we'll get to. But certainly in this case, this is an area where clear and very simple rules of engagement are absolutely critical for your armed forces, because when they're in the middle of a situation, certainly the sniper sitting back that Juan Carlos spoke of, he's not in danger. Presumably, he's got a little bit of time and probably an observer to think through the situation. But in the case of the soldiers who are in the middle of the riot, who are faced with rocks coming their way, and in this case study, insurgents or enemy fighters with weapons, they're in the middle of it, and they need to have clear rules of engagement. You don't want your soldiers sitting there trying to think, am I in a law enforcement paradigm, an armed conflict paradigm? What do I do? Can I respond? You want them to know what their rules of engagement are so that they can respond quickly, save their own lives, save the lives of innocent civilians around them, and act in compliance with your law and policy. So it's critical to have those rules of engagement, and to have your armed forces trained on them. One of the points I often make is you can't just give a PowerPoint briefing and tell people what the rules of engagement are. You have to practice those in vignettes, in training scenarios, in role-playing exercises at training bases before they deploy, so they know how to respond in a situation, without endangering their own lives or others' lives while they sit there and try to think of what the rules are. You need them to know what those rules are. So in this particular case, this may be a case where the paradigm is largely irrelevant, frankly. I mean, that if they've got rules of engagement and they're responding to deadly force, and I'm assuming that rocks could be deadly force. Now, it depends on the size of the rocks and the proximity of the crowd and how hard they're thrown, but a good baseball-sized rock thrown at by somebody with a good arm can seriously maim or even kill somebody at close range. So that a tiny stone lobbed from a great distance by somebody with a weak arm is not going to be deadly force. And so, but a soldier's got to be trained and knows what his rules are, or to be able to respond to either of those situations with the right amount of force to protect themselves. Certainly, rifles, somebody firing rifles at them, that is deadly force. I don't think anybody would have a question with that. So clear rules of engagement and training on those scenarios are critical. Even my last tour in Afghanistan, the year I was there, we had at least 2 riot situations that I can think of where almost this exact scenario occurred, with large crowds, very angry crowds, with both rocks and weapons, and soldiers in vehicles surrounded by the crowd. Which is a scary situation for the soldiers and the civilians caught up in the crowd, frankly, as people start firing weapons. You ask about tear gas. I mean, we take, at least the U.S. position is that tear gas is a riot control agent. It doesn't fall within the prescriptions of the Chemical Weapons Convention. Can be used in this type of scenario, in a riot control scenario setting. Could be used. There's always a danger there of using it. You know, if your soldiers will obviously have to don their protective gear and so forth. But it is a non-lethal method of dispersing the crowd and using non-lethal force, and hopefully preventing the necessity to use lethal force. So it can be very effective in breaking up a riot if it's used properly, as are other non-lethal means that sometimes are probably more prevalent in a domestic setting than they would be in an armed conflict setting. Most combat troops wouldn't necessarily have any of that kind of gear with them. So I'll stop there.
Thanks, Rich, very much for that. So putting aside the paradigm and looking instead at the questions of rules of engagement and vignettes and training beforehand, and of course the potential use of non-lethal weapons techniques to control the riot. David, I don't know if you have anything to add on this particular topic. I'm not sure if David can hear us. David, can you hear us? We seem to have lost David at this stage. What I will do is turn...
No, I think I'm back to you. Can you hear me now?
Thank you.
Sorry about that. I don't have much to add to what my colleagues have said, but I would like to point out two things. And one is a bit of incongruity between the analysis of this situation and the analysis of the first case study. Now, I agree with Juan Carlos that the fundamental paradigm in dealing with this situation is going to be the law enforcement paradigm. But he's said that even if we have armed fighters among the crowd and they start shooting on the law enforcement authorities, we still have the law enforcement paradigm subject to the possibility that if we have a sniper involved, he could target the persons involved. But if we are prepared to say that in this situation we're going to stick with our law enforcement model, then it seems to be, and when we have a real danger to our forces, and we would have some real justification in saying, given the nature, we could possibly depart from this. We still have an international armed conflict going on in the territory. Let's not forget that that is our fundamental assumption. And it seems a bit incongruous to say, now in this situation, it's clear that we have the law enforcement, but when we go back to the situation of the one individual who can be easily captured, no, it's the hostilities model. But my second point, and this relates to what Gloria said, and this is the question which worries me the most, and that is the issue of proportionality. Because here we are going to reach very, very different conclusions on what the rules of engagement are, depending on whether we are using a hostilities model or a law enforcement model. And perhaps Rich would be prepared to relate to this, because if we are dealing with the hostilities model, it's clear that if the person who's firing at me is a combatant or a fighter, then I can fire back and try to hit them, even if there is some danger that some civilian may be killed. And that probably would meet the demands of proportionality. We don't have a similar rule when it comes to law enforcement. And it's very, very doubtful that in a situation of law enforcement, I can use force against a person who's endangering me, even when I know to a large degree of certainty that some innocent individual is also going to be killed or highly likely to be killed. So how does one resolve this kind of issue? It's not quite clear to me. Thank you.
Thank you, David. And so you raise a sort of valid point there with regard to the issue of proportionality and how it's interpreted and applied in this sort of situation. So what I'll do, because we have about half an hour or so to go, is allow Juan Carlos, Gloria, because David, you addressed a question directly to Gloria, and on proportionality, if she wants to respond, as well as to Rich, a minute or two each before we move on to the last case study. So Juan Carlos, if there's anything you'd like to add?
No, I only want to emphasize in what the General said about rule of engagement. I think those are crucial. I didn't mention them, but yes, soldiers have to have the rule of engagement. And thinking about the principle of proportionality, yes, if you are planning to use snipers, you have to take into account this principle in the paradigm of law enforcement. But also, if you are in the paradigm of non-international armed conflict, for sure, you have to take into account the proportionality principle and try to avoid casualties and to injure innocent people. That's it.
Thank you. Gloria, anything you'd like to add?
Thank you very much, Jamie. I will come back first on the riot control agent issue, and I wanted to highlight that indeed when we look at the Convention on the Prohibition of the Development, Production, Stockpiling of Chemical Weapons, we can see that riot control agents are prohibited as a method of warfare. This means that outside situations of hostilities, as such, they would not be prohibited. So I think it's quite important. But in this case, like case study 2, it's true that it's a real issue, because if we talk about the parallel approach, we admit that we are both in a situation of law enforcement and in a situation of hostilities. So the question of using riot control agents it remained an open question, and we did not really discuss that and address this question during the expert meeting. Now, regarding the proportionality issue that David pointed out, I think it's crucial, and indeed that's what is problematic with this case study too, is that when applying the parallel approach, it means that if you can target and kill the fighter in the crowd, and if the fighter is particularly important, this might imply that you have incidental civilian deaths that might not necessarily be considered as contrary to IHL if you take the conduct of hostilities perspective. And that's why I would say that's important also to rely on the policy aspect. It's one thing to say that under a legal perspective it makes sense if we look at what are the key criteria to distinguish between the two paradigms, to say, well, in a particular case, you will have this possibility to apply the two paradigms, but definitely you will need to back up that with a policy position that is more protective and say that you should address the whole situation as covered either by self-defense rules or the law enforcement paradigm. And I would say that the approach taken to possible collateral damages in such a situation should be quite restrictive, because here they are in the middle of the crowd, so it means that if you take every feasible precautions to avoid causing excessive collateral damage, basically you would need somehow to have a sniper or something equivalent that would cause the less harm possible to the bystanders. Thank you.
Thank you very much, Gloria. And Richard, any last couple of points on?
No, Jamie, I didn't quite understand David's point about whether what point he wanted me to respond to. I think he thought maybe perhaps that I was arguing that this was an area where the law enforcement paradigm applied. I don't think I said that. I think what I was trying to say is, in the scenario where a riot is getting out of control and soldiers' lives are threatened, that I'm not sure it matters whether you're under the law enforcement paradigm or the armed conflict paradigm. I think at the end result is going to be you're going to act in self-defense and be able to use lethal force to protect yourself against lethal force. So I'm not sure the paradigm matters, and in fact, in this case study and in the one we're about to cover, I think many of the experts said that it really wouldn't matter at the end of the day. That doesn't mean I think we're under a law enforcement paradigm. So, David, if I misunderstood your point, please correct me and let me know what it is.
Okay, excellent. And very last word on this to Juan Carlos before we move on to the last case study. Juan Carlos?
Yes, I really want to insist in the necessity to rethink the issue of using riot control agents that are legal in international law and not to use in offensive attack, but as a military necessity to protect civilians and to protect soldiers, not as a military advantage principle. But I think that we have to think about this possibility because it could be very useful to protect lives, and right now, because the rule number 75, we are considering this prohibited.
Thank you very much for that, Juan Carlos. And again, a fairly rich discussion on the second case study here. And I think despite the apparent disagreement on some core issues, there was definitely some concurrence on the reflection that, of course, restraint has to be shown, that we are in a complex situation. And ultimately, the protection of civilians, those caught up in the riot and not the fighters, needs to come first in many ways. And that is, of course, a very complex situation. And I think the points that Rich made with regard to the questions of rules of engagement, the proper training, I think it reflects what Juan Carlos was saying as well, particularly important because it will be very difficult once in the context to start looking at what is the applicable paradigm in terms of legal approach, and the rules of engagement will be that much more important in terms of the first call or the first card for the soldiers in the field.